Hi everybody, Tom here, talking this time about the famous dissenting judgment. The judgment delivered by the Chief Justice of the day, Hugh Kennedy. In this case, we're talking about, in this series of videos, Ireland's what I'm calling constitutional case of the century, State Ryan against Lennon, decided in 1935. Now look, there are 3 previous videos in this series. The third of them addresses the judgment of Justice Gerald Fitzgibbon, who was one of the 2 judges who formed the majority. And in that video, I elaborate how that is, as I see it, a formalist judgment, arguably a political constitutionalist judgment, a judgment that I suggest is inspired by or influenced by the experience of the judge as someone who was trained and educated in the British system, or under the British system of parliamentary sovereignty, whereas we're now in a new constitutional state, a state that Gerald Fitzgibbon is sceptical about, which state provides for judicial supremacy. In the previous video to that, video number 2, I go through the technical details of the case. They're somewhat complicated, I suppose, but boil down to 3 simple amendments. Amendment number 10, 16 and 17, passed through the late 1920s and early 1930s. They are amendments to the Constitution that are passed by ordinary legislation on foot of a provision in Article 50 of the Constitution that allows for amendment of the Constitution by ordinary legislation for a period of 8 years. That's video 2. Video 3 on Gerald Fitzgibbon. This is now video 4 on Hugh Kennedy. I'm suggesting that Hugh Kennedy's judgment has 4 themes: a rule of law theme, a separation of powers theme, a natural law theme, and a popular sovereignty theme. There's a great deal in it, so let's go through them in turn. First of all, it's clear, very clear, that Hugh Kennedy is outraged by what has happened. So a military tribunal has been established, as I said in previous videos, a kind of an extra constitutional or parallel legal system, if you like, and our 4 friends from the Tipperary farmhouse are now facing trial before this military tribunal. Early in his judgment, Hugh Kennedy goes through the details of Article 2A of the Constitution, which is this article that has been inserted by the third of those amendments. He points out, for example, that this military tribunal is to be comprised of 5 judges. Judges in inverted commas, you might say. There is no requirement that they would have legal training or experience. They are to be members of the defence forces above or not below a certain rank. They are appointed by government and can be removed by government at the will of government. In other words, they don't enjoy that independence that we associate with the judiciary, the 3 organs of state, and so on, of the judicial branch. The military tribunal hears cases in private. They can try any one of a range of offences, ranging from very serious offences to relatively trivial offences, Hugh Kennedy says, and there is provision in the legislation, or I suppose now in the Article 2A of the Constitution, for retrospective punishment. And it's this, I think, above all else, that Hugh Kennedy finds just impossible to stomach or impossible to justify. For example, in light of the Article 43 provision, which we talked about, I think, in video 1, proscribing retrospective punishment. Now, if you go to the top of page 197 of Kennedy's judgment, you'll see what he's talking about. He's talking about a provision of the legislation, now Article 2A, which gives jurisdiction to the military tribunal to try these offences, which include a provision which says that the tribunal has jurisdiction to try, quote, any offence whatsoever, whether committed before or after this article was inserted in this Constitution, in respect of which an executive minister certifies in writing that to the best of his belief, the act constituting such offence was done with the object of impairing or impeding the machinery of government. Now, in other words, that if the Minister for Justice, for example, wants in 1935 or in 1940 or whatever to deem an act that was committed in 1925 a criminal offence, he or she can do so, despite the fact that in 1925 that action breached no law. And we get a really good sense of what Hugh Kennedy thinks about this, or how outraged he is about this. On page 197 of his judgment, he says, and I quote, "The more one dwells on this paragraph, the more one is staggered by the contemplation of the range of the matters authorised by it." And later on in the paragraph, he quotes Alexander Hamilton from the Federalist Papers when Hamilton says, "The subjecting of men to punishment for things which, when they were done, were breaches of no law, have been in all ages the favourite and most formidable instruments of tyranny." In other words, what Hugh Kennedy is saying is this Article 2A renders this state an empire of men rather than a republic, rather than an empire of laws. He says this is, on page 198, the antithesis of the rule of law and are, within their scope, the rule of anarchy. So Hugh Kennedy gives us a very persuasive account as to why Article 2A does violence, you might say, to the rule of law. But the rule of law is a moral ideal, it's a political ideal, it's not a constitutional rule as such. And you can almost hear Gerald Fitzgibbon saying to Hugh Kennedy, how can you justify this as being unconstitutional in the light of what Article 50 says? Now, I think Hugh Kennedy does give good and persuasive answers to that question in the best part of the judgment, for me, pages 201, 202, 203, and he relies on a different constitutional principle, but one that's a little bit more concrete in this context, namely the separation of powers. Hugh Kennedy points out that what has effectively happened here with this amendment is that the executive, the government, has taken the judicial power away from the courts, where the Constitution vested that power in the courts. The Constituent Assembly, through the Constitution, vested the judicial power in the judiciary, and the executive, through this amendment, has effectively arrogated that power to itself. That is to say, because the executive can appoint and remove these quote-unquote judges at will, that the military tribunal in question has authority to try, which is the judicial power, to try any one of a pretty vast range of offences, that's what's happened here. And at the same time, that the legislature, the Oireachtas, which similarly through the Constitution, or the Constituent Assembly through the Constitution, had vested the legislative power in the legislature. And here we see, Kennedy says, the legislature, quote, surrendering that power with respect to the identification of certain offences as offences, and with respect to the sentencing range, let's say, of those offences, that power over those matters is now vested in the government. Every act, he says on page 202, from the arrest of the individual and the charging him with an offence to the sentence and its execution, is therefore in naked reality the act of the Executive Council, the act of the government. So you don't have a separation or a dispersal of power here, as is envisaged by the Constitution itself, by the Constitution itself, not by some moral law, if you like. What you have, in fact, is the concentration of power in respect of something quite serious and significant for citizens in the Minister for Justice, or in the government of the day. That, Hugh Kennedy says, is why this isn't just morally not good, but rather unconstitutional. Now I have reached my time limit again. It's difficult to upload these videos if they exceed 10 minutes. So, sorry, we're going to have a video number 5. So right now, we're halfway through Kennedy's judgment. We've talked about 2 of the themes, the rule of law theme and the separation of powers theme. We now have to talk about the natural law theme, divinely ordained natural law, which I think is a fascinating but perhaps not so much the strongest. In fact, I think it's the weakest part of the judgment. And then finally, the popular sovereignty theme. And surely, all we need is one more video to do that. Thank you very much. I guess you should check out video number 5 now.